Good evening, everybody. My name is Fran Brooks, and I sit on the board of the New Jersey Foundation for Open Government.
I don't think that's on.
It's not open. Can you hear me back there?
It's on, but get a little closer.
Closer? Is that better?
Yeah.
Okay, I do have a fairly low voice. I want to welcome everybody to our Sunshine Week seminar. First off, I want to thank Belleville High School for making the facility available to us. I'd also like to thank the organizers, particularly Linda Baum, who sits on our board. We have another board member here, Ron Miskoff. Here we go. And our panelists, of course. I will introduce them in a minute or so. I guess when I always start these my talks with factoids. The first nationwide Sunshine Week began in 2005 and occurs each year in mid-March, coinciding with James Madison's birthday, which is on March 16th, the father of our Constitution, and National Freedom of Information Day on March 16th also. As Supreme Court Justice Louis Brandeis said in 1913, sunlight is said to be the best of disinfectants. While some think that this statement is overused, it can't be stated enough. It serves as New Jersey FOG's core principle. The New Jersey Foundation for Open Government is the only organization in the state that's dedicated solely to improving public access to governmental records and meetings. We work to educate the public about OPRA and OPMA, or the Open Public Meetings Act, as well as increase governmental compliance, transparency, and accountability. We were established in 2001, and Mr. Miskoff is one of the original founders, and we're very pleased about that, to have him. Is that, yeah? Yes. Is that better? I can't.
Yeah, just hold it up.
Okay.
Hold it.
At this point, I'd like to introduce our panelists. We have Walter Lords, Esquire, who's an attorney, a licensed attorney in New Jersey. He graduated from Rutgers University in 1996 and from Fordham University Law in 1999. Since 2007, Walter has concentrated on matters pertaining to the Open Public Records Act and the Open Public Meetings Act. He advises and successfully represents individuals and corporations in lawsuits and administrative actions against public agencies that have violated these laws. In 2010, Walter was recognized by the New Jersey Law Journal as one of 10 Lawyers of the Year for his Oprah work. Walter regularly speaks to community groups around the state about OPMA and OPRA, and has served as the president of New Jersey FOG since June 2011. Our second panelist is Michelle Arminio, who also sits on our board of directors. She is a resident of Monroe Township and serves as an elected member of the Monroe Township Board of Education. She is a member of grassroots community action groups that advocate for citizen participation in municipal, county, and state governance. And she has been instrumental in implementing OPMA policies that increase the transparency of Monroe School District's operations. Michelle is also an advocate for local and state environmental protection. She is a member of the Edison Wetlands Association, Lawrence Brook Watershed Council, and Pinelands Preservation Alliance. Michelle is a graduate of Douglas College, Rutgers University. She is a full-time real estate agent and lifetime New Jersey resident, and currently serves as New Jersey FOG's Board of Directors. Last but certainly not least is Tina Renna, in the middle. And she is the founder of the Union County Watchdog Association, a nonprofit 501c3 organization founded in 2005. The UCWA strives to make county government more transparent by gaining access to public records and being a public resource for information. In 2013, she became the first New Jersey blogger to be found protected by the New Jersey Newsperson's Shield Law. The law is one of the strongest in the nation and provides journalists virtually absolute protection against questioning by law enforcement. In 2005, Tina was honored by the New Jersey Foundation for Open Government for her community activism for creating greater access to public records and meetings. In 2012 and 2013, she received a Better Journalism Award from the New Jersey Society of Professional Journalists for online reporting. In 2013, NJFOG awarded her their Tim O'Brien Award for Best Investigative Reporting using the New Jersey Open Public Records Act online. And with that, I'd like to open the seminar. Thank you.
Fran?
Yes, sure. Do you need another one? Here you go.
All right. Well, Fran, thank you very much for that wonderful introduction. Just very briefly, a little bit more about me. I think that about 85 to 90% of my practice deals with the Old Public Records Act and the Old Public Meetings Act, and most of that is litigation. So I handle litigation throughout the state, almost all of it for OPRA, because there's no fee shifting under Meetings Act, and most folks are not willing, unfortunately, most folks are not willing to put their own funds at risk for a Meetings Act lawsuit when they know it won't get reimbursed. But I think I'll just hand it to. Am I doing it?
No, I think it's page plus 6.
Fran's introduction was really good, so I'll just allow my fellow panelists to further introduce themselves if they want, and then we'll get to Oprah and OPMA. That's it.
As an elected official, I have an obligation under the board, under the Ethics Commission for the Board of Education to just tell you that I am speaking on my own behalf. I do not represent the Monroe Township Board of Education this evening. I'm speaking as a citizen with my own opinion. So none of my statements are a reflection of the total Board of Education. And that's one of the rules, and I do want to play by them. So I will be happy to answer questions regarding, general questions regarding Board of Education and my experience, but I am only speaking on my own behalf, and I do not represent the opinions of the board, because that's the full board, and I cannot speak for that. So thank you, and I'm sorry about that announcement.
So one of the things that we like to do at these seminars is we try to be responsive to what your concerns are, because we could probably speak for a very long time about the Old Public Records Act, the Old Public Meetings Act, but our experience has been that when people come to events like this, they have certain specific areas that they want to know about. So at the outset, I wanted to give anyone the opportunity, if they wanted to just raise any questions, but also as we give our talk, if you have questions, just raise your hand and we'll recognize you. We're happy to take your questions as we go along rather than at the end, because I find that makes for a better seminar. So does anyone want to jump into the fray early? Yes, Mary.
Are you surprised? I'm Mary Savakula. I'm a former elected official in the city of Clifton on the city council. And currently, I am probably the town's watchdog, gadfly, and I'm proud of it. I have a question that I noticed today on tonight's city council meeting. I have one question on the city council and one on the board of ed. Tonight, this was listed under confidential items, and I'll read to you exactly the way it's written on the agenda. 2015 street improvements. City engineer presents project status and proposed scope modification for discussion. Confidential item number 1. I can tell you the 2015 road resurfacing project was awarded to the contractor last year, the Smith Sunday, and it was also bonded for last year. So So according to law, I know that any contract modification can only be up to 20%. I don't see how this is a closed session item at all.
So,
If it's an existing contract and you're changing, you can only change or change order. And sitting on a council for almost 5 years, any change order we had was always discussed in public, never in private.
okay, so what Mary's talking about, and it's an excellent question, what Mary's talking about is what issues can a public agency discuss in closed session versus open session. So every public agency is subject to the Meetings Act, the Open Public Meetings Act, OPMA. A lot of times folks call it the Sunshine Law, even though it's in New Jersey, it's not called, that's not its name, but colloquially you'll hear Sunshine Law. So every public agency, when it meets, it has to do so pursuant to notice, and it has to have a public meeting. It means the beginning of the meeting has to be open to the public. And if they want to discuss certain items in executive session, they have to make a motion, they have to say what items they're going to discuss in executive session, and then they can exclude the public. So what Mary's talking about is the Meetings Act doesn't allow the public agency to discuss whatever it wants to in closed session. There's a specific list, there's a limited list of items that public agencies can discuss in executive session. Michelle, what are some of the things that public agencies are allowed to discuss in closed session?
Public agencies, there's actually more of a limit. Very often public agencies are, I'm so sorry. Can everybody hear me?
I can hear you.
Okay. No? Does someone
Yeah, I think you have to.
have to hold it? Okay. Let me talk about the exceptions. In your packets, everybody has a copy or should have a copy of the Open Public Meetings Act. And on page 5 of 8, it tells you the exceptions. So there's two ways to look at it. There's one with a small booklet, that's a reference, and the other one is on the right-hand side of your folder is the Open Public Meetings Act. Those are the exceptions, and very often municipal government agencies do not hold to those exceptions. And it's been my experience that when we know what the exceptions are, as a member of the public, we can keep the government agencies really, will give them a standard that they have to uphold. Because, and that's one of the best things about open government and transparency that we have come to advocate for, because the public knowing what to do is really important, and to say what they can go in for certain contracts. Actually, Walter, I don't know exactly. I know the exceptions.
It could be a personnel issue. If they're having problems with the contractor,
Right.
they won't be allowed to discuss that. It's all a guessing game. I mean, what I would do in my experience is I make sure I keep an eye when they approve the executive session minutes, and then I open them so I can see what was discussed. And they can't take any actionable, they can't act on anything in closed session. They would have to then put whatever if they wanted to fire the vendor or increase their pay, they would then have to put it on the regular, so.
There's confidential information. There is a matter, and this is in your pamphlet, any matter that the information would impair the right to receive funds from the government of the United States, collective bargaining agreements until they are approved, and very often just some personal information if it's an employee or like especially a student in our case and on board. Those are confidential, and you're allowed to go into closed session for that. But again, it's very limited, and there are very few things. But I would think what Mary's talking about is not one of them.
Yeah, I mean it's very interesting. Tina mentioned the minutes. One of the things you should always get are the executive session meeting minutes and the resolutions that authorize the executive sessions, because you can see what they're you should be able to see what they're discussing in executive session and who they're meeting with. And one of the big things to look for is who exactly are they meeting with? Because when Mary said, well, they're bringing in the engineer to talk about X, Y, and Z, to me that's a bit of a red flag, without commenting on your specific situation. Because if an attorney is meeting with the board in executive session, there's a very high likelihood that that attorney is giving legal advice, and that's a permitted use of executive session for the board to ask questions of the attorney and for the attorney to provide legal advice. That's very appropriate. However, there's really nothing that an engineer can do that's privileged. I can't think of anything. So when I see executive session meeting with engineer, well, there's really nothing an engineer can say that disclosure would harm the public interest. So that's a bit of a red flag. A lot of times budget discussions, if the budget discussions are not about specific personnel, those really should be in public. If there's ever meetings with other public agencies, those should, or representatives of other public agencies, those should also probably be in public, not in private, because there's no exception for, I can tell you that public agency lawyers disagree about this, but there's no exception that allows one public agency, a full quorum, to meet with a representative of another public agency and have a contract negotiation. The contract negotiation exemption in the Meetings Act is to allow internal deliberations, not internal negotiations. What they should be doing is they have a representative of one body meet with a representative of the other body, not a quorum of one. And again, I think I'm right, because even the public agency lawyers who I've asked that, I've put that question to them. And I say, look, you guys don't think that a quorum of your governing body can meet and have a negotiation, of a private negotiation in closed session with another public body, do you? And half of them said yes and half of them said no. Okay, so the gentleman in the front had a question, then Penny, you're next, then you're next.
My name is Rory Moore, I'm from Nutley. Nutley uses the executive session just to have conversations. Because I have one outstanding right now, they went into pending litigation. But I do believe there's law that it has to be like 90 days and they have to release it if there is no litigation.
So
I'm not sure if the time limit's on it or not.
Mention who the pending litigation is with as well. They have to mention the party, right?
They just generically say pending litigation, and then it's up to you to pursue it, because that's when they have their general conversations.
Well, let me ask my fellow panelists a question. Do you think that if a body is going to discuss pending litigation, which is a legitimate exception, should they be identifying the name of the case that they're going to discuss in the resolution authorizing the closed session?
Well, you know better than me, but I believe if it's litigation that's been filed, then they have to reference it in the resolution before they go into executive session.
But if I threaten to sue you, that's just pending litigation.
Right.
Rory's going to sue you, maybe. And if you wanted to discuss it with your attorney, that's perfectly legal. But they use that's used as a tool to say, okay, we want to have a meeting about something we don't want open, we don't want a sunshine. So they'll use pending litigation, because I have one right now for that precise reason. But I think there's a 90-day limit on it. They have to release it. There is no litigation.
Well, the rule, I see you now. The rule is that the executive session meeting minutes must be prepared and disclosed within the exact term is escaping me, promptly. The law says promptly. So what does that mean in terms of the reality? It means 30 to 60 days. However, with respect to executive session minutes, they can redact those portions of matters that are still active. And there's also a school of thought that says when you're dealing with personnel issues, medical issues, student issues, attorney-client privilege, there's a school of thought that says those privileges last forever. I've had mixed success in chipping away at access to minutes about closed matters. I agree with you that if a matter is closed, the interest in non-disclosure goes down, and the cases say that, but the interest in non-disclosure doesn't become zero. So for an active case, very unlikely you're going to get anything about an active case. So be careful not to confuse the obligation to create the minutes, 30 to 60 days, versus the obligation to disclose, which is really, it's a very fact-sensitive question. Penny.
Can I just add to that? I'm sorry. One of the things I do while I watch this particular governing body, I do things routinely on a monthly basis, and I request all lawsuits filed against
Yeah, I just did
the
that.
verbiage is escaping me right now. But I also ask for tort claims. So that's pending litigation. If somebody files a tort, it'll come up in there. It's a game. You know, you really have to learn the tricks of it. And it's not, you know, they don't make it easy.
To the nomenclature of the law, the word that they actually use is potential litigation. We are going in to discuss potential litigation, which, could you describe from a legal nomenclature standpoint the distinction between potential litigation and pending litigation, if there is one?
Well, sure. I mean, the potential litigation is a lawsuit that's been threatened, or where I think the public agency reasonably knows or should know that there might be a lawsuit. Right. Now, once you have an actual lawsuit, then that brings a lot of other exemptions into play. So you could, discussion about a lawsuit could fall under the deliberative process exemption. It could almost certainly would fall under the attorney-client privilege. And if they're discussing a settlement, well, a settlement agreement is a contract, so that would fall into contractual negotiation. Technically, it would fall into contractual negotiations. So I think that the grounds for going into closed session, once you have an actual lawsuit, they have several grounds. And I mean,
So can they just have a blanket statement, potential litigation, and not have to disclose what the potential litigation is concerning?
Now, what I think Penny is referring to is the motion or resolution to authorize the executive session.
Yes.
And oftentimes you do see potential litigation. I don't think that that's sufficient. Now, there are circumstances where I think if the potential litigation is public agency versus someone, I think then it would be in the interest of the public agency to not reveal who they think they're going to sue, because maybe that would harm the interest of the public agency. But oftentimes it's the other way around. I think if a public agency receives a notice of tort claim, then it would be pending litigation, Jones versus public agency. I think then that they should disclose. A lot don't. And the problem is, your remedy is, well, you write a letter, or you say, well, hey, pending litigation, what case is that, or what potential case is that? And then if they continue to refuse to disclose, then the remedy is to sue them under the Meetings Act, which is, that's too much stick, because it's suing them. It's not like the Records Act, where you can go to GRC, you can file for free. Under the Meetings Act, you have to do a lawsuit. So it's $250. It's a lot of paper. It's going to court. It's much more difficult process. And that's one of the problems. That's part of the dichotomy between the Records Act and the Meetings Act. The Records Act, it's much easier to try and enforce it. The Meetings Act has relatively much higher burdens trying to enforce. So that's why you get situations where people can get away with for years pending litigation.
To that point, I would, as someone who goes to a lot of municipal meetings, even before I was an elected official, if I saw that on a frequent basis, that pending, that would be sort of their way of saying, we're not really telling you what we're going into closed session for. That would raise suspicions on my part, and I would constantly be asking, what that litigation is. And what happens is, even if in the beginning it seems like they're not answering that question, they're not doing it, ultimately, if you start to talk about the Open Public Meeting Acts require certain things, if you do a little research, that closed sessions are supposed to have a resolution, a proper resolution, they start to get the idea that you know what you're talking about, and there starts to be compliance. Just an example, it's not about closed session, but when I go to our municipal meetings and they see resolutions on there, they used to just put a resolution by title. They still don't put the value of the resolutions, but they are putting now the statutes, and they're also putting the lawsuits. So we're getting, you know, it takes a long time, it's a slow process, but if you go with the information about the Open Public Meetings Act and what the requirements are, there's a slow process, and they tend to come around because you say it every
It's been 2
day.
years and it hasn't happened.
Well, then there's a different...
But my question is, so does pending mean that something has been filed?
Yes.
Thank you. That was my answer. I was looking for. Potential means not filed. Pending means something has been filed. Thank you.
So it could be a civil suit or a tort claim, and you can open that. I've also had some success with the Open Public Meetings Act issues, and at least getting them to behave a little better. The county prosecutor is supposed to enforce the Open Public Meetings Act the way the law is written right now. So you can write to the county prosecutor and ask them to intervene. And, you know,
Who is that
usually,
process? Who is that process now?
I don't know, you would contact your prosecutor's office and ask them.
Well, it would be the Essex County Prosecutor's Office.
Yeah.
Look, I mean,
And they should have someone assigned to the Open Public Meetings Act. I mean, it's just another thing you could do to sort of, you know, the carrot and the stick, but it is an option. I've had some success in Union County with that. And as far as them at least telling them, you know, you have to do things a certain way, never holding them accountable really, but that they have behaved a little bit better, and they're very politically connected to the county prosecutor's office. So if it works there, you know, I say it's worth a try.
yeah, and I
It's
mean,
a letter, you write a letter.
yeah, you write a letter to the county prosecutor, and sometimes it's infrequent, but sometimes the prosecutor's office will write a letter. I've seen them. They will write a letter to the public agency saying, you're violating the law, don't do it again. And I've even seen one letter, this was in Somerset County, where they said, don't do it again. If you do it again, we're going to sue you. And I'm not aware of any lawsuit initiated by a prosecutor under the Meetings Act, but it is something they take seriously. Again, the range of responses goes from nothing all the way to the next time you do it, we'll sue you. So it's something that's absolutely worth your time, because technically, again, unlike Oprah, Open Public Meetings Act violations are within the jurisdiction of the county prosecutor.
Okay.
Yes, ma'am.
Okay, I have two questions. My name is Yvonne, also I'm from Jersey City. I go to every council meeting, and what I notice is that the mayor gives away, I'll give an example, public land, 99 years for $1 a year. I'm looking it up, and it's an LLC. Where can the public find out who these LLCs are without going crazy? That's question number one. Now, I have a neighbor of mine who has this problem, but she wasn't able to come, so I'm asking a question for her. The same mayor will send out emails saying, we're asking you questions. And it's talking about agencies and whatnot. But what she did, she used her name and her son's name, and then later on, we get information back from the mayor for his political website. So he's gathering, he's using, what is it called, SurveyMonkey, whatever it is. He's sending these things out as legitimate stuff saying so-and-so is happening, and then he's using the information for his own personal email gathering. So she asked them, you know, on Oprah, well, I want the information too. And they told her no, she could not have that information because it's private. But the mayor is using it for his own political stuff. And she actually found out by using her son's name, as I said before, and he didn't, you know, sign it up. So he wouldn't go online and click on these things like she would. So emails, if the mayor used that for his own personal stuff, can the public use it, and how do we get a hold of that? And where do we find who these LLCs are? Because in Jersey City, we give out tax abatements like you wouldn't believe, redevelopment loans, and these are all LLC people.
Okay, so I'll answer the LLC question first. The easiest and best way to get information on an LLC is just go to the New Jersey Secretary of State's website and you do a business registration search. And what you want to do is you have to order a business, a current business report. I do this all the time, but you order a business status report and it costs you $6.25. You can do it over the internet and they'll email it to you and make it available to you right away. And it'll tell you all the names of the officers, the agent for service and process. It won't tell you who the owners are for an LLC. It's one of the reasons why people have LLCs is because the owners of the LLC aren't recorded. It's just the officers. But even then, you'll see who the president is. And you can get an idea of where they're coming from. So that Secretary of State's website, $6.25 per report.
Wow, that's a lot.
But if there's some kind of legal document, wouldn't the owner, the president of the LLC have to sign the agreement?
Well, that's an excellent point. Any agreements, if there's a pilot, if there's a pilot agreement, then yes, an officer, at least an officer of the company, you would, when you hear about all the pilots,
Explain the pilot is payment.
Taxes. It's a fancy way of doing a tax abatement and reducing someone's tax liability for 99 years or whatever. I guess it's 99 years now.
Well, we do 40 years, 30 years, 40 years constantly.
If that becomes a contract, you should be able to operate through the city. That agreement should be a public document at this point. So if you do an Open Public Records Act for that specific, if you know what land it is or what it is, or you can just say you'd like to have the list of those agreements, those particular agreements in a month's time or a week's time, wherever you think they might have occurred, or a 6-month period of time, you'd like all of those.
Now your second question, it starts to become really tricky because you start off with our email address is confidential, and there's cases on both sides of this, and the trend is for email addresses to be treated as confidential. That's the trend in the case law. So there's an argument that, hey, the email addresses are not confidential. So then the second part of it is, let's assume that they're not confidential. Well, do you get access to the mayor's campaign list because you're pretty sure he's drawing, and this is not the first time I've heard this, you're pretty sure he's drawing at least parts of his list from Jersey City's database? And the answer is, I'm not sure. That's a very tricky case because, whether or not the mayor is acting appropriately, that doesn't necessarily mean you get access. Maybe it means the mayor should stop having access, assuming that's what he's doing. Again, it's not the first time I've heard this issue come up. If the mayor's acting improperly using emails, maybe someone should tell him to stop. But I don't, from an Oprah perspective, I'm not sure if that would necessarily give you access to your own emails. When you sign up for the Jersey City email list, is there any promise that they would keep your information confidential? If there is no such promise, well, then maybe that's what's happening. Yes, ma'am.
Pat Cameron, Bloomfield. We get the same resolution.
You speak up a little bit.
What?
We'll repeat the
I'll
question.
repeat it. I'll repeat it.
We get the same resolution for going into closed session time after time. A meeting, it says land acquisition. The next meeting, it says land acquisition. There's never any detail.
Land acquisition's a little tricky.
I'm
You're getting
distilling
there?
it down.
Sure.
I mean, it also says litigation, land acquisition. Now we're in contract negotiations. They list the possible people that they could be negotiating with. But nobody, well, that's only some part of the time. Nobody ever comes out and says anything. Can they use a boilerplate for going into closed session?
Okay, so the question is, can the public agency use a boilerplate motion or resolution when they're going into closed session? You know, the school boards are particularly bad at this. And you know, the answer is they're not supposed to, but enforcement is rare. I agree with you that a lot of public agencies simply lack meaningful detail in their motions. If they're negotiating with a bargaining unit, they should identify the bargaining unit. You know, what's the big deal? If there's a potential land acquisition, they should identify the parcel unless it would harm the public agency's interest, which it may. If they're in contract negotiations, they should identify the counterparty. If they're in litigation, they should identify the name of the other side. Because then, while they're not required to tell you what the lawsuit is about, then you can go make an over request for the complaint. If it's a federal lawsuit, you can go on to the federal court's website and order copies of records. But they make you go through hoops to find out that information. So again, it comes back to the problem we discussed earlier, where they can kind of get away with this vagueness because it's a high burden to file a lawsuit over something like that.
Again, I would write to your county prosecutor's office if it's a habit of theirs, and you have nothing to lose. And, you know, at least then looking into it puts them on notice that someone else is paying
And then,
attention.
in terms of her question, Bloomfield has a monthly newsletter. I Oprah'd the names of the email addresses. I got all of them. I Oprah'd the cat and dog licenses. I got names of people with cat and dog licenses, their addresses, their emails. And then Bloomfield refused to give me the animals' names, saying that the animals' names were confidential. I threatened to sue, they turned it right around.
That's just weird.
Going back to your question about the closed session resolutions, do they have a public forum after they come out of closed session? When does very briefly, when does the closed session take place?
If they've actually voted on something, or if they've actually decided on something, most of the time, they come out and vote in public.
Okay, I don't know if everybody heard that. If they've decided on something in the closed session, they will come out and then either read a resolution, and at that time, even if they haven't been specific, I mean, I believe in specificity when you go into resolution, closed session resolutions, but at that time, if they're voting on something, it should be very clear what the vote is about, and then I would, and Walter can correct me, I believe that under the Open Public Meetings Act and Open Public Records Act, you would be entitled to the full information because they've actually acted upon that in public. And you should have all the details of what that land acquisition is. Walter?
No, certainly after it's been approved.
Right.
Certainly.
So if very often closed session I'd like to speak a little bit about closed session resolutions and closed sessions. There was some question in boards of education as to when you should go into closed session. A lot of boards want to go in the very beginning, then the people don't know when it's going to be over, then they don't know when the meeting is really supposed to begin. Some people want the closed sessions late at night, and then the part of the public doesn't want to wait that long for a public forum, which is usually after. It seems to me some government agencies are really reluctant to have public sessions. In Monroe, our public sessions are when we open up the meeting at 7 o'clock. The public session is right before the actions are taken to the agenda, so the public can speak to the agenda items. Then generally the closed sessions are at the end of the meeting. However, the Monroe Township Board voted to have a public session after all of the actions were taken. So we have a public session before we go into closed session. So if someone doesn't want to wait to see what the end result is of a closed session issue, they can go home. And which is very unusual, I'm very proud of what Monroe Board in total did, is that we have a closed session after we have another public forum after the closed session, specifically on the closed session. Now, rarely do people stick around and wait, but if it's a closed session issue that is important to somebody, and before I was elected, believe me, I stayed there until 12 o'clock if it was something that I wanted to find out about. And now we try to respect the public and we actually have 3 public sessions. So it's possible. People can ask for that, see how it comes out, but you can go to the website in Monroe and see our agendas, and at the end of the agendas it talks about that. So it's possible. These are little victories, but they're important victories that benefit the public.
Yeah, and so by comparison, only townships and boards of education are required to have a public comment period, and they're only required to have 1. So what Michelle's board is doing is sort of very much in excess of the minimum requirements of the law. Okay, well, ma'am, and then ma'am.
Stephanie Belli, when they're going into closed session about land acquisitions, should they be telling us what they're doing with the land, that they're going into thinking about buying this land and telling us about it, instead of just finding out, oh, we decided we're going to buy it, here's the resolution, vote done?
Well, the question is sort of how much information should the public get before the discussion about land acquisition. I mean, the answer is that it's tricky because, especially with land acquisitions, if they disclose too much before they enter into negotiations, they could be hurting their interest. Land acquisition is really one of those things that you're almost always not going to find out a lot about it before it's at least there's a contract in place. Unfortunately, because of the nature of the transaction, I think. Yes,
My name is Terry Court, and I'm a spokesperson for the Nothing Parent Advocacy Network. And I have a question. Back in September, the Nutley Board of Education had awarded a particular individual a very large sum of money. And I was kind of questioning this, and I sent him an open request regarding the settlement agreement and things like that, and the check. And I was told that that particular person who had been identified this was student record, and we couldn't give you any of this information, nothing between the attorneys or anything. So, okay, I took the letter, which is right here, that telling me that it's student record, and then I went to the Board of Ed meeting just last week, and I said, is this particular individual, is he currently a student, or was he a student at that time? And you could have heard crickets, because it was like nobody wanted to answer that question. So I have now submitted the same question, and I also had a private conversation with a board member who said to me, oh, Terry, we have to try to really protect these people, and we have to do the right thing. Okay, and I said, well, you know what? Doing the right thing sometimes is telling the truth. So I'm in this position to find out whether or not that particular individual was currently a student at that, or is a student now. And wouldn't he might be identified as in terms of numbers, like a student number, student ID?
He was identified by name.
By name.
Well, but they won't say if the $121,000 that was awarded, if this person that they named, let's just call him Joe Smith, they will not say if Joe Smith, who was given $121,000, is a student or not.
Right.
So that we're thinking that because he was named, he's not a student. But if he's not a student, then the public should know why a person was given $121,000, and what we're getting is the runaround.
Right. So the question, and I'll rephrase it a little bit. I think the question or the issue is, to what extent do school boards and public agencies have to disclose how they spend money, especially sort of settlements or payments that are parts of settlements or results of lawsuits. And there can be a tremendous amount of pushback on this issue, but the rule, and there's an exception and then there's controversy. So the rule is that all payments and all settlement agreements are public records. That's the rule, because a contract is a public record under OPRA, and a settlement agreement is simply a contract. All checks are public records, all purchase orders and vouchers. Really, anything to do with money is absolutely a public record. Now, where you get into a possible exception and the controversy is, well, what if the payment is to a student? Now, what confuses me about your scenario is that you would never have a payment to a minor. You can't make payments to minors. You would make it to the minor's parents. Or more likely their attorney. There's really no circumstance under which you would simply just cut a check to a minor. So then the question is, was there a payment to parents or the parent's attorney, as part of a settlement? Well, what you should be able to get, ideally, is the entire settlement agreement, or if there was a consent order, you get the entire agreement. Because theoretically, if there is a minor involved or a minor's parents, they should be identified by their initials. Now, a lot of times you'll get those settlement agreements unredacted, but more and more you have school districts redacting the docket numbers or redacting the initials. And you have some going even farther. You have some judges saying, well, you're allowed to redact initials from settlement agreements if it's minors. And that's where you get to the controversy, because now you even have judges who are disagreeing over that. So, to sort of answer the question, I think that if you have a settlement agreement or a payment, those records, the associated records, they're always public. But there is a school of thought that says, well, you should be able to redact personally identifying information, such as a student's full name and address and their parents' full name and address. Well, yes, if it's just a settlement agreement. And there it's really, the schools aren't really doing their job. If the school has someone's full name in the settlement agreement, like a parent's full name, they're not doing their job right. It should be a number or it should be initials. But you should get the docket number, you should get the initials. You don't have the right to a student's full name or anything that you can use to connect the student, but absolutely you should get the settlement agreement.
It would be in the.
But they gave us the names.
How about just a copy of the check?
They won't give us anything.
Not even a copy of the check?
Student records that are not entitled to.
What about the civil complaint, the original complaint, the payment and settlement is
They
coming?
won't give us anything. We ask for the settlement statement, we ask for all correspondence between the district's attorney and this particular individual's attorney. We ask for a copy of the check. They said absolutely not. The information you seek is student record.
Well, they're wrong.
I would ask for the civil
Okay,
complaint.
now how do I respond to this? Do I go to the Government Records Council and say,
Well, the question is what's my remedies? What is my remedy? And then the answer is a little tricky, unfortunately. If you're, let's speak, sort of broadly. If you're denied access to a record, what can you do? Well, obviously you can always do nothing, but your two real options are to file a complaint with the Government Records Council or to file an Oprah lawsuit with Superior Court. Now, for Superior Court, you only have 45 days from the date of the denial to file. If you go to like day 50 or day 60 or day 70, you're out of luck.
You
And there's,
place the request again.
well, yes. Now, my concern is that there might be some judges who say, hey, if you're just placing the request again, you're just trying to get around the statute of limitations. So, yeah, you have to be careful of that. And then, what's the way around that? Well, maybe one of your colleagues makes the same request. That's okay. And then, the other option is the Government Records Council. The good thing about the Government Records Council is that filing with them is for free. You can file by email. It's very easy to file with the GRC, but a Superior Court complaint, that might get resolved in 2 to 6 months, which I don't know if anyone has ever been involved in civil litigation, but civil litigation takes between 2 and 5 years. So 2 to 6 months, that's very, very quick. GRC cases can take 1 to 2 years. So, and the other problem is that to file with the Superior Court, not only do you have to move fast, but your filing fee is $300. So if you're doing it pro se, you'd have to cough up that money. GRC is free, but it takes much longer. But the more, really the trap is that courts and the GRC don't always decide the same issues in the same way. So there's some types of cases where you'd be better off going to court, and there's other types of cases where you'd be better off going to the GRC. In your particular situation, the GRC has taken a very expansive reading of what is a student record and how broadly the student records exemption should be interpreted. So under GRC cases, even a settlement agreement involving a student is a student record, which that's not the law. If you go to Superior Court on that one, you'll get the student record. But unfortunately, the legislature created this sort of parallel track, and the two tracks don't talk to each other. So, frequently you might be better off, having one of your colleagues file a request and then go into court, because 90% chance you'll win. If you go to the GRC and ask for a settlement agreement that involve the terms of a student issue or a student, they'll say it's a student record and you don't get it. So there's pitfalls in terms of your remedies. My view is that if you're dealing with a lot of technical non-compliance, let's say you make an OPA request, and most of you probably know they have 7 business days to respond, and then maybe they drag it out. It drags out 30 days, drags out 45 days. They ask for another extension. Say, okay, look, I'm fed up with this. It's been 80 days. I want my records. That's a case you can take to the GRC, because that's sort of like a technical violation. It's not a case I would take to Superior Court, because a Superior Court judge, a busy Superior Court judge might say, hey, look, why didn't you just work it out with them? They didn't say they wouldn't give you the records. They just dragged their feet a little bit. What's the big deal? The cases I like to take to Superior Court are the ones where there's a substantive dispute. The public agency is saying you don't get access to that record, and I think you do get access to the record, and that's a good case for a judge to decide. You guys have any thoughts about remedies, GRC versus Superior Court?
GRC takes a very long time, and even if I recommend, if you do go to the GRC, that you consult an attorney and maybe they'll do it for you. You're just not going to have the time for the paperwork, so it's always worth it.
Yeah, a lot of things are time sensitive when you're dealing with a government agency, and the Government Records Council, which is the GRC, doesn't always really satisfy the need for getting that record, especially if it's like land acquisition or something that really has a time-sensitive element to it. So I would agree with Tina that consulting an attorney who knows Public Records Act, Public Meetings Act is really the best avenue after you get one. I think there was some, yes.
I have an Open Public Meetings Act question. Basically, a public library, this is in Westwood, New Jersey, a child saw porn in the children's section of the library, the mother complained, and the library reacted by passing a policy to ensure children could continue to access porn in the children's section of the library. I know that sounds funny, but that's what happened. The way the library did this was by not holding these meetings in public. They didn't discuss the actual changes in public. They just discussed a few things about how they were very child sensitive and aware of the First Amendment, things like that, but they didn't discuss the actual changes. In one executive session, for example, that they held, I went to the county prosecutor in Union County, because that's where the library is, and I told the prosecutor that there was a tape of the executive session, but the prosecutor never got the tape and instead just took the minutes that were provided to the county prosecutor the day after the 45-day statute of limitations ran on the case. So I could not bring an action at that time. And then the prosecutor said there was nothing there. I sued them eventually. In January, I did sue the library. In February, they had an executive session which was not on the agenda. I think it has to be on the agenda. I'm going to ask you that. And then for the executive session, they said, we're going to meet for litigation reasons. And again, they didn't say what the litigation was, though I could obviously assume it was me. But I'm thinking they don't want to say it because they don't want it in the record. They don't want people to know what the title is and so on and so forth.
Okay, so the question is essentially, how much information do public agencies have to give on their agendas? And to be honest, I think I don't know if you were here, we talked at some length about litigation and what information they have to disclose about litigation that they go into. Just very quick recap is, if they're going to discuss, X versus Y, they have to identify it. And we went into that earlier. Now the agenda part of the Meetings Act is frankly not very strong. Most public agencies will, at the beginning of the year, post notice that states the dates of all of their meetings. And a literal reading of the law allows them to number one, just post the dates of their regular meetings, and then they don't have to do anything else. So a lot of folks might say, hey, don't they have to give us an agenda before each meeting? Well, no. There's a school of thought that says, and I think it's the better school of thought, there's a school of thought that says no. If they're having a regularly scheduled meeting that they gave notice about in January, then they don't have to give a new agenda. They only have to give an agenda for meetings that they didn't give notice about back in January. And that's what makes this portion of the law very weak. In addition, the law says that the agendas must be given out to the extent known. So a public agency will always have that out where they can say, well, we didn't know about it, or we didn't know about it at the time. The bottom line is that when it comes to agendas, public agencies have a lot of discretion about how much or how little information they give out in advance. Some of you may be familiar with the Opterbeck case where Judge DeWine in Bergen County greatly expanded the amount of information that public agencies have to give out in advance, and he got reversed. And the appellate division reversed Opterbeck and said, no, you only have to comply with the law, you don't have to go beyond the very specific requirements of the law. So, unfortunately, the way the law is written, you have a very limited right to more information in the agendas. Now, the amendments would change that. Every 2 years, the legislative cycle is 2 years. Every 2 years you have the Open Public Records Act and Open Public Meetings Act amendments. And one of the things that Senator Weinberg has wanted to do is to give the agenda requirement more teeth. And every time the opponents of the act push back on that because they like the flexibility and the discretion. And I don't want to use the word hide, but that's what ends up happening. They have the ability to just sort of hold back on the agenda items. So it's just, bottom line, it's just a very weak part of the law right now.
Since Walter brought that up, I'd just like in general to bring up one of the reasons why New Jersey Foundation for Local Government exists, and people like Tina and most of probably the people in this room are here for, because we want to participate in our government. We want access to proper information. We want to know what's going on and be informed. Walter mentioned Loretta Weinberg. She is a senator in New Jersey. She has been proposing amendments to the document you have in your packets, the Open Public Meetings Act and the Open Public Records Act. We also gave you something in your packet, your legislative lists. What we're trying to do at FOG, and we would ask every one of you to do very often after these meetings, we'd say, okay, sometimes it's frustrating, but we want to be involved, we want to do something. What is it that we can do to promote transparency? One of the things that we've come up with is take a look at who your legislators are, write to them and say, we want you to support the amendments that Senator Weinberg is proposing to the Open Public Meetings Act and to the Open Public Records Act. The more diverse crowd that we have within the state talking to their own legislators and asking them to take notice of these bills. Like Walter said, they come up every year, and there is a disincentive for our legislators across the state to approve these amendments. But when people like you in the crowd write to their legislator, or just make a phone call, but we prefer both. You know, give them a call. Give them, you know, you can go to our FOG website. It talks about the numbers of the current bills that are out there. If you just say you're in support of that, and ask your legislator, are they in support of it? A lot of times they're going to say, oh, we don't need, we'll have to get back to you. But those are the kinds of very simple things that bring transparency to the fore and shows your legislators that we are actually looking for change. And it's a very simple thing to do, and it's very, very positive. And it's a good action for all of us to take on a regular basis.
And what's fascinating about how legislation works, which has sort of been an education for me, is that the legislation gets proposed and it gets immediately referred to a committee. And then it sits in committee, and what happens is different groups will approach the sponsor and tell the sponsor what's wrong with the bill or what's right about it. And those meetings, they're all confidential. And all the communications are all confidential. And so NJFOG will bend Senator Weinberg's ear, the League of Municipalities will bend Senator Weinberg's ear, and her staff will work on the changes because they'll want the changes to become law, they'll want it to pass. So I don't want to say that, it's not that they're trying to please everyone, but they'll try to set up a series of compromises in the legislation to make it acceptable to everyone. And then you get to a point where, let's say it's Thursday, and at Thursday at 4:30 p.m., the Judiciary Committee or whatever committee that these bills are sitting before will send out an email at 4:30 and say, the bill's going to come before committee on 1 p.m. next Tuesday. And then you get the draft bill and you'll see things you like, you see things you don't like, and you'll have, like, you know, literally 4 days notice. And, you know, so we have to scramble to get people to go and testify at committee. But more importantly, if we see stuff we don't like, you know, we'll need people to call and write in the next 3 or 4 days. So that's why Michelle's call to action is very important, because we hope you sign up with us, because there may come a time where we'll need you to send emails to target particular senators, target particular members of the legislature, and say, look, we're specifically unhappy with this, because, you know, while it's important to have that type of communication going on constantly, you know, we're talking about this in March. It may hit committee in, say, June. That's what happened last year. We had a big fight. There was this 3-week period where we had a big fight, and ultimately the amendments didn't go anywhere because they didn't have sufficient support. But it tends to ramp up very literally in the space of days. It ramps up to very intense, and frankly, with the current round of amendments, that's been happening now for about 5 years, where it becomes very intense, usually over the summer, and then, you know, the bills don't have sufficient support, and the amendments, they don't have sufficient support, so then I don't want to say they die, but they kind of gets quiet. Well, eventually they die because the 2-year session ends, and then Senator Weinberg reintroduces them. She usually tweaks them to try and get more support, and then the league opposes.
But I assure you that if everyone in this room called their assemblyman and senator and just talked about the Open Public Meetings Act and the Open Public Records Act, it would be a shock to the legislative offices. But it would go a very long way to at least let them know, or their staff know, that there are people out there that even know what that is. The Open Public Meetings Act, the Open Public Records Act is something that's been under the radar for too long, and it is a way for citizens really to get action on a local level and state level, and it really empowers us to really have the democracy that most of us, I think, are really looking for, especially in these days. We're all talking about.
Just in case anyone doesn't already know, the two bills that Senator Weinberg has introduced are S. 1045 and S. 1046.
Okay, we're going to repeat that again.
That's a simple.
S. 1045
Right.
and
1046.
S. 1046. You can look those up on the state website, and even if you just call your legislators and just mention those two and tell them what they are.
You can put an email on those, too.
And I think we have it on the New Jersey Foundation for Open Government website under education, under the legislation tab, and we probably have them all out there. And our website has really come a long way. We have a wonderful website, and it's very informative.
And I can assure you, the towns in which you live are doing the same thing. They're passing resolutions. They're sending 70, 80, letters to Loretta Weinberg's office. They do this all the time. The League of Municipalities does it. The Clerks Association does it. The County Clerks Association does it. New Jersey School Boards Association does it. They're all very active.
But they're not in favor, Jeff, very often for the passage of these bills. Let's be clear. They're making amendments that, in some of our opinions, are weakening the bills.
Yeah. Yes, sir.
Hi, Frank Fleisch, Belleville. Tomorrow, allegedly, the Township Council is going to have a special meeting to discuss the affordable housing plan. The two newspapers of record are Belleville Times and Star Ledger. They did publish a legal notice in the Belleville Times. As of, I think, today, they have not done one for the Star Ledger. So that's my first question, like, how does that affect this? And secondly, they said right in the notice that at least a few council people would be basically calling in by telephone on the meeting. I wonder the legality of that as well.
Okay, so the first question is, what type of notice do you have to give? And the second question is, can members of the governing body participate by telephone? The first part is easy. For meetings that weren't part of your annual notice that you gave in January, you have to provide 48 hours notice to 2 newspapers that cover your area, and you have to post the notice at town hall, or I forget what the or is, but it's at least at the public agencies. You have to post it conspicuously at the public agency. Now, the tricky part about the notice is that the notice only has to be transmitted. There's no requirement that the notice actually be published by the newspapers, because you can't force a newspaper to publish something, and they don't want to force the public agencies to purchase advertising. So the only requirement is that the notice be sent in time for the newspaper to publish it if they wanted to. Now, what does that mean in time? It means by their advertising deadline. So, if you've got a weekly, and I just had this situation in a town in Hunterdon County. If you have a weekly that publishes on Thursday, and their ad deadline is, Monday, then you have to get them the notice by Monday for a Thursday deadline for a meeting the following week. So if one of your newspapers is just a weekly, which frequently happens in places like Hunterdon and Warren and Sussex, you've got to send the notice really about 8 days ahead of time, or else it's not sufficient notice. But if you're dealing with dailies, then yes, if they send it on Sunday for Tuesday, then you get into the issue of, well, what's their publishing deadline? I think some attorneys would say, well, Sunday's fine for a Tuesday meeting. I would say only if that meets their publishing deadline, their advertising deadline. Because if you send it in Sunday, but they've already got their spread set by Sunday for Tuesday, which probably most of the time they do. I don't think that's sufficient notice. And frankly, that's something that's never been litigated that I know of. The much more interesting question is, can people call in? I mean, I know there was a case on this like years ago. I don't have an answer for you. I think it's probably okay if it's reasonable. You know, what does reasonable mean? I know one of my colleagues, attorney colleagues, there is a case on this, but it's old. I think that they shouldn't get into the habit of doing it, but if it's for special meetings that they didn't anticipate, it's probably okay. You know, use it but don't abuse it. Do you have a policy?
Well, actually, I've been reading Robert's rules, and if the organization is organized under Robert's rules, I just recently read a segment, and don't quote me on this, and I'm not giving advice here, but I think if you looked for it in Robert's rules, it did talk about that people calling in really was not a sufficient meeting, because the whole point of the meeting is for deliberation, and if they're not really there, they're just on the phone to vote, they're not sufficiently deliberating in the public sphere. So check Robert's rules. If they go by Robert's rules, there may be some insight into that.
And maybe the public agency has a policy.
Right.
You know, because they may not be violating the Meetings Act, they might be violating their own policy.
She had a point.
Yes, ma'am.
Okay, I have a question about school board committees and subcommittees. Some of this might be obvious, but I'm not sure. In regard to over requests for written committee or subcommittee minutes, do they have to be ratified first or cleared by the next meeting of the full school board or of that particular subcommittee at their next meeting? And then, the second part of this is, what if these minutes or subcommittee minutes are audio or video recorded? How soon can they be subject to an over request? Because they're not written, they wouldn't necessarily need to be, repaired. I just want to know how fast is the avenue to getting information out of that committee or subcommittee or school board?
So the question essentially is what rules apply to committees or subcommittees? And the question is in the context of school boards, but you know everyone has committees. Unfortunately, if a committee or a subcommittee consists of less than a quorum, now the law says, the law doesn't use the word quorum, it uses a different term which is escaping me right now, but courts have interpreted it as a quorum. Something majority, do you remember? Effective majority. The Meetings Act only applies to effective majorities. Now, most courts have interpreted effective majority as meaning a quorum. So, a quorum is what your governing body defines it as. Usually it's just the majority of the then filled seats of your governing body. So, if you have a committee that consists of less than a quorum, the Meetings Act doesn't apply at all, unless that committee is specifically authorized by law to spend funds. Because I think that if that committee is specifically empowered to spend funds, then it itself becomes a public agency within the meaning of the Act. However, if it's a committee that's advisory, it's there to make recommendations, then you're just dealing with the Records Act. So unfortunately, if the Meetings Act doesn't apply, then they wouldn't be required to create minutes. They wouldn't be required to give you notice. They wouldn't be required to do agendas. And so they really then have a lot of discretion about whether or not they want to create minutes. Now, the previous round of amendments would have changed a lot of that, although over time the requirements were watered down, where I don't want to say it became almost meaningless, but it lost a lot of its initial teeth. But they never passed anyway, so you're still in a world where the Meetings Act doesn't apply at all to committees or subcommittees. So then it's only a question of, well how Oprah play into it? I think that if the committee or subcommittee, if they're creating records, if they're making audio and video recordings, if those are all done in the ordinary course of their business, then they're all subject to Oprah. Although with the committee or subcommittee, if they're making recommendations to the broader body, those might be exempt from Oprah as deliberative. Even the minutes, if the minutes are, well, we recommend you do X, Y, and Z, those might be exempt as deliberative. So it gets really tricky. Well, it depends on what they say in the minutes, or it depends on what they say in the meetings.
When you're talking about this quorum, is it a quorum of that particular committee or a quorum of the school board?
It's a quorum of the body, the full body.
Full body.
Yeah, and some committees and some government agencies, in particular, if you look on the Monroe Township website under school board and then you looked at committee meetings, Monroe Township allows the public to be present during the committee meetings. However, it is because there is not a quorum of the full body that the public is not allowed to participate. They can be present. The only committee that the public is not allowed in is personnel for confidential reasons. So one can impress upon their government body to allow people to go to the committee meetings, at least be present, and that has been occurring in our town for a while. And also some of the workshops, and I know workshops are probably not subject to Oprah or Oprah, I'm not sure, but like Monroe Township's having a budget meeting for the municipality, and they do allow people to sit into the workshops and listen to the budget hearings, but they are not allowed to participate. And I have gone in as a citizen and taken videos of the workshops. So, and I'd like to get to another thing when videos, after some of the questions go on. I'd like to talk about videotaping public.
But it's reasonable to ask before a meeting, say there is a quorum, say if you can find out that there is a quorum.
Well, then it would be a different kind of meeting. If there's a quorum, then it should be a public meeting. And it has to go under the Open Public Meetings Act, isn't that correct?
Yes.
If there's a quorum of the public body, they cannot meet without proper notification and proper public, and then there should be a public forum. So then that's a different set of rules.
Because
So
there's always a lag. There's like a lag until you can't get the information right away, you gotta wait a month till the meeting.
Well, in general, as a citizen, when I go to just government meetings, I believe, and you'll always hear, well, we haven't approved the meetings yet, regardless of the government body. We haven't approved the meetings that they're only draft. And we've had discussions in NJFOG that you can ask for a draft meeting and a draft copy, and if it's stamped draft, that's all it is. It's not approved minutes. Ask for a draft copy, and I have been successful at getting that. I'm sure Tina might have something to say about that.
Yes, basically I don't really rely on meetings to really watch a government body, that, especially if you know they're secretive. I really rely more on the records.
We've had actions taken that came out of subcommittee recommendations that, didn't involve, may not have involved receipts and checks being made or contracts or anything like that, but involved the use of school funding for supplies for these actions. I don't know if that can matter.
Emails are very important to request as well.
Yeah.
Email correspondence, you find a lot of information in there.
So one of the things we heard was workshop. There's meetings, there's workshops. It's important that when your governing body meets, it doesn't matter what they label a meeting. If a quorum of the governing body is present, that's a meeting, whether they call it a caucus or a workshop or whatever they want to call it. It's a meeting. The public is entitled to attend, and they're only entitled to have an executive session if they first, and exclude the public, if they first pass an appropriate resolution or motion. Now, one of the interesting things is that, sometimes they'll say, well, we're going to have an executive session only meeting. Well, there's no such thing as an executive session only meeting. Every meeting under the Meetings Act has to start out as a public meeting, even if the first thing they do is pass a motion to go into executive session. Every single meeting where there's a quorum has to have, two things. It has to start as a public meeting and has to have an opportunity for the public to comment, for towns and for boards. Although almost everyone does it anyway, because there's actually no requirement that, say, like the county or utilities authorities, they don't have to have public comment, even though almost all of them do. Penny?
On Open Public Meetings Act, very specific question. Public hearings, for instance, a budget hearing, where they are proposing something that they're going to vote on. They ask the public for their comments. 3 I've been to have made specific recommendations concerning the budget. They close the public hearing, and then the very next thing they do is go for the vote. Is any deliberative process required by the body to consider public comment made during a public hearing?
No.
No? What's the point?
Well, I mean, you've got to remember something. One of the issues with these laws is that you can't tell someone that they have to talk, because that runs into First Amendment concerns. So that's why you can't force a public agency to answer the questions that you ask at a meeting.
When they're asking the question, does anyone...
Well, you said public comment.
Well, would anyone from Nutley like to say anything about the proposed budget? Okay, so then people say, could you put a cap on salaries for this year? Could you consider this? Could you consider that? So my specific question you answered, there is no, according to Open Public Meetings Act, required deliberation on public comment in a public hearing.
Same answer.
Okay. Great.
I mean, it's optics, right? I mean, you would like to think that they listen to you and they
Right,
consider
that's
what they
exactly
say,
right.
and it's bad optics, but
But it's no
unfortunately,
legal-
no.
Okay, the second thing is back to committees. Nutley's Economic Development Advisory Committee consists of 10 or 11 people, I think. The meetings are closed to the public. The minutes are not available to the public unless they are open. They are 3 sentences. Who was there? And they're, less than a page, okay? However, back to they make recommendations. You said that they were not covered under OPMA because they were making recommendations. They are making recommendations to the governing body, the DOC, to spend taxpayer dollars. Okay? So they made a recommendation that they hire a consulting company. The consulting company does a resolution, and the consulting company is hired. They repeatedly are bringing recommendations to spend taxpayer money to the Board of Commissioners, but the public is not entitled to attend their meetings or to have their minutes, and when the minutes are open, they're 2 sentences.
Right, and the problem is the committee or the commissioners, they're not bound to accept those recommendations. If they were bound to accept the recommendations, it'd be different. But unfortunately, they are structuring it in a way that it's a little bit of an abuse, because you've got the black hole of this committee, which they make sure that it doesn't have a quorum, and they're making these recommendations, which you can say, well, they're protected by the deliberative process privilege because they relate to policy, and then the deliberation at the committee level or the commission level is slight or non-existent.
Correct.
But that's again, it's bad it's very bad optics, because it leaves you wondering why they do anything.
But stay with Penny, familiar with the case, doesn't there have to be correspondence if you go from this committee that are totally unregulated? Somehow it has to be communicated to the commission. Does that become?
How are
No,
they,
what-
how are they getting the advisory position?
Probably
When
through an
it's
executive
open,
session.
you get nothing.
Right, because they might be having conversations now if Senator Weinberg recognizes this problem, and at some point in her amendments, she would have required committees to prepare quarterly reports, which could have been written or oral. So that folks recognize that this is a problem, and there's been a proposed legislative solution, but it didn't get out of committee.
Let me just talk about that Walter always gives very succinct legal situations, but as a citizen, that is disturbing to me, that we have a right under the Open Public Meetings Act to be present when our government bodies deliberate. And when they don't deliberate, get up and ask questions as to why they're not having a discussion. How are you making these decisions? Because if you're not making decisions in public, you must be making them in private. And that goes to Tina's request to maybe where is the conversation occurring?
Right.
That is, and then if the conversation is occurring over emails, or those are the public records. But we can also say to our public officials, you never have a discussion about how this is going. The Open Public Meetings Act says we should be present for deliberations. Please deliberate these subject matters. These are important. Taxpayers are paying for them. So again, it's a little bit of a stand up and say something kind of thing.
Again, I would point you to whatever records, especially if you know what you're looking for, what you're interested in, I would request the records. For instance, Union County government has a $600 million budget. Their agenda meetings, their workshop meetings, I've been to one that lasted 8 minutes. And that included, the prayer, the salute to the flag. If I relied on that meeting to get information, I wouldn't get any. You have to Oprah.
So can you give an example of specifically an Oprah for that situation?
It would depend what I'm looking for. For instance, the lawsuits. Again, I habitually, once a month, we request the county check registry. We can see who's getting paid. A lot of information in that. We request any civil suits filed against the county or their agents. We request the tort claims. And that's a lot of your situations that you mentioned today would come up there. Your settlement agreement had to originate somewhere. There has to be a civil complaint somewhere or a tort claim somewhere. So that information would be in there. It would depend what you're looking for. I totally recommend that you get into the habit of habitually requesting these records, and hopefully they put some of them online. If not, it just becomes a habit. I have a standard Oprah request that I place once a month, and I change the dates on it, and I submit it.
Okay, with your indulgence, I'm going to go to someone that hasn't asked a question yet. So.
My name is Tucker Kelly. I am an addict. I'm addicted to Oprah and Oma. How you doing, everybody? Appreciate it. First of all, thank you very much for having us. The assembly is there. I'm sorry?
Move to Clifton. We need more people like you.
Yeah, come to Rockaway and or Google me. I do have a question though for Sabrina. Now, I follow a lot of the stuff that you do, and I talked to you a long time ago. And I was so intrigued on the tenacity that you had going after Union County, being Union County watchdog or self-proclaimed, if you will. And I was fortunate enough to meet Mr. Laurels and develop a great relationship, and we have some fun between our municipalities or our county. However, we're labeled as freaks.
Consider this boss.
We have I own 12 properties in my town alone. I pay over $80,000 in taxes. I have a 4-year-old daughter who's not even in school yet, where I get even somewhat of a benefit from my taxes. So I have a huge interest in where my money's going. And I always considered my council, the mayor, being a stockbroker, and I'm a shareholder. And I want to see the dividends that are going on from their actions in the right way. And basically, from seeing budgets go up every year, $1 million or plus, that these people really don't know how to manage not only the town's money, but their own money and some stuff. But my question is, how do you go from being an individual that's an activist in the town concerned about your tax dollars to the higher spectrum of being a problem, a cost because of your requests. I've been called worse by better, but I mean, now at meetings, we have every council meeting, and there's 2 a month, there is a tally of Oprah requests that have taken place in the state at the beginning of the year. They'll say 100, and then they'll say, well, Mr. Kelly is 33 of those 100, and now they assemble hours to the request of how long it takes to do that. In my town, I know some other towns do the same thing. But my main question now, and I know it's not about Oakmont or anything else, but just personal experience in some of these people of probably being a little concerned of being vocal and reaching out and asking questions to Oprah. How do you get away around that labeling aspect? Because I know that I'm not free. I just have a huge interest that's going on there, and I will hold my governing body to the task. But when I go and I run for a political position, I've cost X amount of thousands of dollars to the town by my requests or my information or my lawsuits and stuff like that, rather than you forced me or drove me to make those requests because you wouldn't answer my questions, you wouldn't deliberate accordingly, you wouldn't provide records that I was lawfully allowed to have. I had to compel you and force you to do that when you could have easily given me a 10-cent document and copies of charges versus spending $12,000, $10,000, $25,000 in legal costs.
Do you blog or anything? Do you have a website or
You know what?
blog?
I don't. I have a Facebook page, which is just Tucker Kelly for Mayor. I put on there, I really don't, I don't get into a whole bunch of commentary about Oprah and public records, and I'm kind of like a real quiet, cool guy, but I'm an advocate for a lot of people that are interested in Oprah and try to educate them as well and inform them what's going on. But in my town, I do let everybody know kind of what's going on. But if you consider Facebook, which is really, I don't consider it a blog, like you're a blogger, like you're a serious chick. Blogging wise. You are, I mean, you want to.
A blog is, anyone can have a WordPress blog,
They
it's
can.
free.
They
And
can.
then if someone Googles your name, that's what'll come up. Your side of the story will come up. I've had blowback, just as you described it. You know, one year they ran, there was a political campaign, I wasn't even running. They put up a website attacking me. I wasn't even on the ballot. It was bizarre.
Yeah.
It was bizarre. But you just have to, it comes with the territory, and especially if you're effective, there's going to be blowback. They have the bully pulpit, and you just have to, you know, I believe in, you know, you have to stand up to bullies and expose them. So if they're being rude at a public meeting, even if you have to civil disobedience and interrupt them and say, call them out on it, they'll learn not to do that. They'll learn not to push you around. You sort of have to push them back a little bit.
You know,
Without getting arrested, I'm not advocating that.
No,
That
and
would
I
be
understand that,
unpleasant,
but you know, it's fundamentally what you're saying is so accurate and so honest. And
They're
you
bullies,
can imagine,
especially bad government. They're bullies, and you know, they think that if they push you around, you'll go away. So it's up to you if you know, you're dealing with bullies.
Well, it
That's your
seems that-
question. How do you react to that? You can't change them. It's your reaction, and how you present yourself is going to be your reaction to them. So I would recommend having a blog and having a way to have a, you know, post the video of what they said, and then you write about what they said, and that's your side of the story. So they can't control that.
Laugh at them.
Well, you're going to get into that because there's Flores versus Pine Hill matter in Wisconsin,
Right.
which is a great case. And I had a matter where a school board administrator had removed 2 positions of custodians, only to fulfill those positions with his sons. And they did not provide any notice or anything else or whatnot. And I videotaped the session of it, and they wanted to confiscate my video. And Mr. Laurel and I have Fred Snowflack, who was a reporter for the Daily Record, had wrote about it because he happened to attend it as well. But the administrator lied. He misinformed that it wasn't advertised in the positions that his son had got, which were put at a higher rate than a starting individual or somebody in their 3rd year. So I've gone through the videotaping, I've done that. If you go on YouTube and you type in Michael Dapperson, which is our mayor, I videoed him and put it on YouTube because he collects health care and also has health care from his primary employer.
Well, if I lived in your town, I would vote for you. I wouldn't consider you a
They
fake.
do,
I would
they do.
appreciate it. And I can tell you, there's no town, everyone in here, I applaud every single one of you. I mean, go to a meeting, you look around, you're probably the only one there. Every single town, you look around yourself. No one has a crowd of people doing this. So you are very unique individuals, and I applaud you.
But I also think that getting organized and getting people of like mind, like the New Jersey Foundation for Open Government, I keep plugging it because it's a real organization where you have people that actually we help each other. Most of us are here because of activism. I have to tell you, the first person I met during Open Government was this young lady here. I was thrilled to meet her 20 years ago, and it was because of her that I got into New Jersey Foundation for Open Government and got places in my government. Anyone who speaks up in a government that's not receptive to change or looking to keep the power structure is going to be intimidated, is going to be had rude comments. I still get rude comments against me. I have the council people looking over my head, and actually, after a while, people recognize what you're doing. Some people will never like it, but some people will, and people come up to me and they go, wow, really? They don't like when you stand up and talk, do they? But keep doing it. You'll get more people in. But also, what happens is you become a little bit more empowered when you join organizations like New Jersey Foundation for Open Government. We are a diverse group of people, anywhere from very conservative to very liberal. But we have one thing in mind. We want open government. We want to trust our government. And we want to move it forward with transparency. And it's like coming to where people can give you advice, where we've all helped each other. Fran, I would love for her to just say a few things about what she goes through. She's the only one in her town that shows up, and she's doing a great job. And you know, they want to have a chilling effect on people who speak at the mic. So the first couple times that I did it, I had an upset stomach, I was shaking, I had to drink about 3 bottles of water. Now I'm an old hat, nothing bothers me. You know? Yeah, that's the experience. So that's a learning curve. You know, you're going to get from, if you really believe in this, like most of us do, you're going to be terrified the first few times you go up. And then if someone else comes and they say something, what you need to do is tell them to come back. Don't be afraid. Because the minute someone insults you from the podium, they hope you never come back. When they see you the next month or the next week, you are totally empowered. And that's what New Jersey Foundation for Open Government would like to do. And people like Tina and like you, every one of you in this is more empowered than most. My one suggestion that's helped me is learn a little bit about these laws so you can tell them what you're entitled to when you get up to speak. You mentioned TAR, and I don't know if I'm taking up too much time, if I can stop if you want, but Taurus versus Pine Hill. The first time I took a camera to a meeting, they went crazy. And then I knew that I was within my rights to do it. So they ended up putting a section in the back where it said, public video. And it was great because what happened was every time, in cases where the room was packed, I had a place to stay. I had my video camera and I was guaranteed a place to stay. So it is terrific once you just stand up to it and push back. Another time when I first brought a video camera to a Board of Ed meeting, one of the board members said that he was in the Actors Guild, and if I wanted to take his picture, I would have to pay him. That was a big joke. And the next meeting, I read the statute. I read Taurus versus Pine Hill. It's never happened again, and now everybody takes it. So it's a process that you just have to keep doing. And I'm sorry I'm rambling on.
It gets easier.
I'd like Fran to can you just give a little bit of your
Just in answer to Mr. Kelly, I have been called a serial abuser in a lawsuit, okay, in a complaint, or a response to a complaint.
Laura, would you call the same?
Yeah.
Okay. I have been, I've done 2 things. I started a blog, 3 years ago, and that has empowered me hugely. It's called the Tabernacle Journal. I live in southern New Jersey in Burlington County. I am just about the only person who attends my meetings who is on my side. But ever since I started, the only thing I can say about my blog is that it has empowered me. And over time, I have insulated myself from all of that criticism because my committee continuously tries to paint me as this person who has caused taxes to go up. I hear this constantly. And my response is, if you would just give me the records that I have requested that are legal under Oprah, if you would just give me the information, I wouldn't sue you. And it's a very simple formula. And over time, I have just completely insulated myself from the issue of spending taxpayer money because the bigger issue is accountability and transparency. And over time, you will insulate yourself.
You know, just to follow on that, I do have a different methodology as far as the blogging and not blogging. I'm always interested in reading blogs. Again, I do read your blogs, and you're always very interesting in what you go through yourself. I guess it could be a mirror to a lot of other people what they go through as well as what you go through yourself. However, in my situation, what I want to accomplish and how I focus on it, I never want to foreshadow what I'm doing or where I'm going with it. Because what I do is that I actually compel my government to follow the rules that you're supposed to do. I make my requests, I do it numerous amount of times, I do the same thing with the Public Meeting Act. When I know that there's not something there, because I usually know the answer to the question before I'm even asking it, but I want something to be validated by the document to support what I'm saying, or the lack of document supports what I'm saying. And then I sue. And it's that simple. Whether I sue under Oprah, whether I sue in civilly, I'm suing the family out because they are not eligible for benefits that they've been taking for 18 years. And it's $2.5 million I'm trying to get back to the taxpayers. I don't get anything out of it. I pay out of my own pocket. I enjoy it. And it's a great thing to do. But I do believe in the blogging aspect, it probably makes it vents. You're connected only to a selective people that want to listen to the blog. And then there's ones that just don't get it. And even some of the people that are in our government, including the clerk or custodians, don't get it. And that is such a hurdle to go up. It's a slippery slope to try to climb. It's impossible to reach the apex of that. It would be more frustrating than what I'm doing in my cause to go to that level. I do read blogs about me, and I laugh, and I sue, and I find out who the blogger is, because they always try to be in that dark basement in their mother's house. And, just
Talking
type
about
it away.
anonymous posters.
Yeah, where you're, I
read
can't
those.
read it, this is the thing.
I
So-
haven't read those in years. I refuse to read them. If you have something you want to say to me, you
I'm
can
the
say it in
same way.
person, but
I'm
I
the same
don't
way.
read the anonymous stuff, so those people don't get to me.
It's true.
Well, Tuck, tonight you're going to have the last word on that because I know there's hands, but we're getting to the point where we're limited in time, and I have to conclude sort of the public portion of it. That's why we did questions from the beginning, because people ask questions throughout. That way you get to ask almost all of your questions. If we held questions to the end, there'd be a mad rush for 2 questions rather than an orderly procession of 20 questions. So first I want to thank you for coming. It's always a good time from our perspective because we do feel that we kind of support each other, and a lot of times I felt a lot of good emotion in the room, even though sometimes this stuff can be very frustrating. We spent a lot of time trying to give folks information through our Facebook page and our website. So with Facebook, like us, it makes it easier for you to get our alerts. We do send out alerts, we do send out information. You can sign up for that through our website. We try to use it but not abuse it. So you might get notices about things like this. You'll get legislative alerts. We try to put on Facebook information about lawsuits, new lawsuits, the results of lawsuits. That's something where, that's a space where we tend to be particularly comfortable in. So those are ways of getting resources and information. And also on our website, we have guides, we have blogs, we have references to articles. So there's a tremendous amount of detail about this sort of thing. And I will offer, I don't know when they're going to kick us out of here. Someone told me it was 9:30. So I think if you want to come up to us, privately for at least for a little bit. I mean, I know I have about an hour and 20 minute drive home, so I can only stay so long. But there's info@njfog.org. Send us emails. Oh, do you want to close it?
Yeah, Fran, take the mic.
The only thing I'd like to say, I feel like I'm in a political campaign these days. We're an all-volunteer organization, and we ask if you are able to help support us and the work that we do statewide, and join New Jersey FOG to help support our work. We have inserted a membership form in the yellow folder, but you can also join us online at newjerseyfog.org, and we would appreciate any contribution that you can give to the organization. And we are a 501c3, so it is a deduction. Thank you for coming, Joe.
I have one question. I see all the cameras here. Is there a place that someone's going to post these that you can see?
We're going to post it on our website. Lee Dory, who sits on our board, will enable that. And so you'll be able to pick it up on our website in probably, how long would you say? A day or so. We'll display it, we'll put it up on the website.
Governments take like months. Why don't you wait till like months?
Well, that's the good thing. Even us volunteers can turn it around in a day. Thank you very